Assalamualaikum. I am Alysa Sofea, and today I'll be presenting firstly on the introductions on the Local Government Act 1976. So, Local Government Act 171, also known as the Local Government Act 1976, is a significant Malaysian law that ensures financial autonomy for essential services, facilitate administrations, and divides authorities into city, municipals, and also district councils. And this also mandates some transparent financial management procedures, which can facilitate the implementations of long term development programs that are customized to the specifics requirements of communities.
Assalamualaikum and hi, my name is Azmina Azmi. I will be presenting on background of Local Government Act. MPSA governed by Council of Elected Representative and appointed official established in 1963. Shah Alam is located in Malaysia, Selangor State. In 1978, the organization transitioned to decentralization in order to promote balanced urban growth. The organization is responsible for the development and expansions of infrastructure as well as urban planning, public facility development, and environmental stewardship. The organization objective include the enhancement of quality of life and the development of community engagement. The organization is managed by Council of Elected Representative and appointed officials.
The power of MBSA. MBSA is in charge of infrastructure, community services, public health, sanitation, licensing, urban planning, environmental management, law enforcement, and economic development. Building approval, garbage management, business permits, road upkeep, community programming, public facilities, environmental protection, local security, and economic development are all under its purview.
Next, I will be presenting two significant court cases involving Majlis Bandaraya Shah Alam and BSA. The first case is Kumpulan Kenanga Research Sdn Bhd versus Majlis Bandaraya Shah Alam. It's involved a legal dispute over a tenancy agreement between Kumpulan Kenanga and also MBSA, who sought to terminate the agreement for business operations. The plaintiffs filed a lawsuit against MBSA for improper terminations of agreements, claiming the termination was justified by the LRT three-part and right project, arguing that the plaintiff's use of their permissions is violated the agreement. The court awarded damages to the plaintiff, stating that the terminations of MBSA was illegal due to insufficient justifications based on the Local Government Act 1976. The court's ruling underscores the significance of the clear and well-founded decisions by the local authority when terminating tenancy agreements, emphasizing the need for fairness and equity. Now let's move on to the second case, Aero Express Sdn Bhd versus Majlis Bandaraya Shah Alam. It's a case involving the premature terminations of a tenancy agreement for two land parcels. Aero Express terminated a tenancy agreement with MBSA, citing the public necessity, leading to a lawsuit for damages originating on April 18, 2022, based on the land's early terminations. The court ruled in favor of the plaintiff, granting damages for early terminations of tenancy despite MBSA lacks of justifications for the land's immediate public use, addressing the issues related to the Local Government Act of 1976. The court ruling underscores the significance of clear communications and mutual understanding in the tenancy agreements, emphasizing the need for locality to balance administrative duties with the tenant rights. In summary, both cases underscore the need for transparency, well-justified decisions by the local authorities when terminating the tenancy agreements, ensuring the fairness and equity for trust and cooperation.
For the next part, I will explain regarding legal provisions for objections. The first one is related to street closure, which are mentioned in section 67D and 67E, that says that aggrieved parties can appeal street closure notice to the state authority within 1 month, and the local authority cannot proceed with the closure until the appeal period expire or the state authority rules on the appeals. The second one is objection to local authorities valuation list. It states in section 142 subsection 1 and subsection 2 that individual can object to the valuation list 14 days before its revision date on grounds such as overvaluation or incorrect valuation, and the local authority must investigate these objections, providing an opportunity to be heard in person or through an agent. The next one is objection to amendments to valuation list. Mentioned in section 144 subsection 3, aggrieved parties can object to amendments to the valuation list 10 days before the specified time in the notice and have the right to be heard in person or through a representative. The next one is appeals to objection decisions, which stated in section 145 that dissatisfied individual can appeal the local authority's decision regarding objections to the High Court with the requirement to pay the disputed rate amount. And the High Court's factual decision are final, but legal issues can be appealed to the Federal Court. Last one is objection to attachment, which is mentioned in section 154. It states that parties can object to property attachment by petitioning the High Court for holding or the magistrate courts for movables for a stay order, but they must first deposit the full arrears, interest and costs with the local authority.
Okay, now we'll be moving on to next question, which is 1C, the rights of interested parties. So there are few interested parties involved, which are the property owners, the residents, and also the stakeholders. So interested parties may submit their written objections within time frame stated, and these objections must be sent to the appropriate municipal authority and explicitly stated their reasons for the objections. And the act guarantees that the peoples and groups have enough time to prepare and submit their views, which allows for a fair and open assessment process. When the local authorities receive the objections, they must examine before making their final decisions. In certain situations, the legislations may require local authorities to organize public hearings so that the opponents can also express their concerns in person. These hearings also can provide an opportunity for open communication between the local administration and the community, which can result in increasing understanding and also collaboration. If the complaints are not properly addressed by the local authorities, the interested parties may be able to pursue legal actions. This, however, might include appealing to a higher administrative entities such as the government state offices that oversees the local governments, or seek out judicial review in court. Uh, the review procedure enables the court to determine whether the local authority decisions was made in conformity with the law and procedurally fair. Uh, so a few objections here, which are the section 15, and this section discusses the creation of bylaws by the local administrations, and it mandates that any new bylaw will be publicly announced, giving time for objections to be raised and reviewed. And the other section is sections 142, refers to the objections to valuation list for property assessments, which allows the property owners to contest the assessed value of their property.
Hi, Assalamualaikum. My name is Azmina Azmi, and today I will be presenting on question D, the reason for making an objection. Without further ado, according to Local Government Act 1976, Section 142 agree with on specific ground can make an objection in writing to the local authority. This ground include a holding value beyond its retailable value, a holding that is not retailable, an omission of any percent of holding from the valuation list, a holding value below its retailable value, a holding or holding that should be valued differently. Objection must be submitted at least 14 days before the time fixed for the revision of the valuation list. All objections are then acquired into, and the person making them are given an opportunity to be heard, either in person or by an authorized agent. There are several compelling reasons for making an objection under this legislation. First, legal compliance and procedural fairness. Objection may arise when there are perceived violation of legal procedure or regulation. For instance, if a local body fails to comply with zoning regulation or necessary consultation process, affected parties have genuine reasons to object. This made transparency and equitably preventing unlawful by local authorities. Secondly, impact on property or rights. Local government decisions that directly impact property rights or interests can be objectionable. Concerns might include development project in reducing property values, changing the area character, or violating rights to access or use land. The Act provide a formal process for affected parties to convey their concern. Environmental and public health issue. Local authorities must enforce environmental standard and public health regulation. Objection can be raised if proposed development threaten public health, air quality, water resources, or environmental sustainability. Community impact and public interest. Objection often reflect broader community concerns. Residents might worry about action impairing public places, cultural heritage site, or community facilities. The Act recognizes the importance of community well-being, allowing stakeholders to discuss the potential impact on local identity, social cohesion, and overall quality of life. Procedural errors or misinterpretations. Objection can result from procedural mistake, improper regulation, implementation, or public misinterpretations. In conclusion, the Local Government Act 1976 promotes legal principle and equitable governance by allowing residents and stakeholders to submit objection on various grounds. This process safeguards community interests by ensuring procedural impartiality, protecting property rights, addressing environmental impact, and maintaining community welfare. So, thank you for your attention.
Hello, my name is Wilma and Anak Jayong, and I'm going presenting on the procedure to make an objection. So first off, we starting with understanding the context. So according to section 142 of the Local Government Act 1976, an objection is any written communication opposing a local authority's decision or plan. This act allows any individuals, regardless of residence or any interest in that area, to report complaints and appeal the government for justice. We go for the second procedure, which is to specify the requirements. This letter should include the objector's name, address, and a phone number for acknowledgement. Additionally, the letter should provide well-reasoned, fact-based justification or any references to relevant laws and statutes, which is particularly those related to infrastructure or environmental impacts. For the third one, which is delivering the objection, this one must typically visit the local authorities' office, such as MBSA, to physically delivering the objection letter and supporting documents. This to make sure the objection is being received, logged, and assigned as a reference number which is communicated to the objector. So here's the continuous of the previous slide, which is the procedure to make an objection. So on the fourth, which is reconsideration process, when an objection is filed under section 142 of the Local Government Act 1976, the local authority initiates a reconsideration process. This involves examining the facts and legal guides for the supporting the objection and assessing its potential community impacts. On the fifth one is decision making. The resulting written decision includes a summary of the objection, an outline of key points discussed during the hearings, the evidence that inform the decision, and last but not least, the reasoning behind the decision. At last, appealing. Grounds for appeal can include insufficient disclosure of concerns, procedural errors, or bias. Before appealing, the objector must file a notice of appeal outlining the reason for the appeal and providing supporting documents.
The function and role of the relevant agencies. Selangor State Government and Economic Planning Unit, Ministry of Housing and Local Government and Plan Manager, Department of Environmental and SW Corp, TNB, Shabas and Telekom Malaysia, Ministry of Health and Fire and Rescue Department, Public Work Department and Land Public Transport Agency. All of them ensure objections truly evaluated, addressing urban planning, environmental infrastructure, public health and community concerns to make informed decisions aligned with legal manners and public interest in Shah Alam. Issues faced by local authorities. The first one is lack of financial resources. The process of obtaining an additional budget might take a short while when local authorities like MBSA run out of money. The second one is overlapping jurisdiction. While local government units do not correspond with district lines, there might be misunderstandings about their roles and problems with cooperation between the various agencies. The second one is insufficient autonomy. Residents may become frustrated and inefficient as a result of this. And the fourth one is corruption and mismanagement. This issue is exacerbated by a lack of accountability and transparency measures.
There are 9 challenges in providing urban services, which is one of them is financial constraints. Local authorities facing financial constraints, including limited revenue, inconsistent reliance on federal and also state contributions, and insufficient infrastructure investment, which is can affecting their ability to provide services. While on the second one, which is the governance and also administrative issues, Malaysia facing those and also political meddling challenges with inefficiency and limited public participation, hindering effective law enforcement and also service delivery. While on the third challenge, which is capacity and competency limitation, where the local authorities facing those in developing capacity due to the limited experience, insufficient training, high turnover rates, and difficulty in hiring experts, which can slow down successful urban development initiative. While we go for the fourth one, which is legal and regulatory challenges, which the local administrations also navigate a complex legal framework, facing challenges like outdated legislations and financial constraints can lead to the confusion and inefficiency. While we go for the social challenges, where the MBSF facing the social issue like public participation, service delivery, urbanization, and population increase. The effective planning and management are crucial for retaining trust and addressing community needs. So for the rest challenges, we'll present for the next slide.
Next, I will continue the challenges faced by the Majlis Bandaraya Shah Alam or MBSA in providing urban services in Peninsular Malaysia. The sixth one is environmental challenges. Balancing development with environmental sustainability is a daunting task. It requires legislations to promote the green spaces, reduce carbon footprints, and manage waste effectively. The climate change impacts such as flooding and extreme weather demand through the planning and resilience building initiative. The MBSA also takes into considerations that managing pollutants, including air, water, and noise, is vital for the well-being of citizens. The next one is rapid urbanization and increasing population density present the substantial challenges also. This growth puts immense pressure on all the infrastructure and services, necessitating the developments in housing, transport, health, and education sectors. Economic developments and infrastructure strategy must evolve to meet these demands. Other than that is traffic congestions is another critical issue, especially in Shah Alam. Addressing this requires effective urban growth planning and substantial investment in public transportations. Establishing well-organized and frequent transport routes can help alleviate this problem, but it also remains a persistent challenge of MBSA. And lastly is the public health. public is a major concern in a large city. Issues like infectious disease, environmental health problems, and accident require meticulous management. MBSA undertakes various activities to supervise sanitations, health practices, and healthcare preparedness. The COVID-19 pandemic in 2022 highlighted the importance of having the robust healthcare facilities and preparedness measures. So despite these challenges, MBSA has implemented measures to enhance the efficiency and accessibility of its services. This includes sustainability programs, public participation platform, and e-government services that aim to enhancing the green spaces, reduce energy consumptions, and promoting recycling. And in conclusions, MBSA is committed in addressing the challenges through the innovative solutions and continuous improvement. By enhancing governance, involving the community, and implementing sustainable practice, we can create a better future for residents of Shah Alam.